It's very clear that once a member of a state house of assembly defects from a party that sponsored him or her to the seat, it stands to vacate that seat. These matters have gone to court in several other plethora of cases, and the result was always the same. Don't forget, last year, 20 members of the Cross River State House of Assembly also did the same thing, and a federal high court sitting in Abuja, presided over by Justice Taiwo, actually ruled that those members, 20 members, had lost their seats. A similar thing played out in Ebonyi State, where 16 lawmakers defected together with His Excellency David Umahi to the APC. His learned brother, Inyang Ekwo, of the Federal High Court in Abuja, also ruled the same way, following an old judgment of the Supreme Court that was laid down in 2015 when it happened in Ondo State. So the Constitution is very clear on how these issues should be resolved and ought to be resolved, which is to the effect that these lawmakers cease to become members of the River State House of Assembly constitutionally. Now,
thank you so much. I welcome you to Politics Today. I'm your brother Secret. In this video, we want to look at the issue of the Supreme Court arrogating to themselves the power to make law. Is it provided for in our Constitution that the Supreme Court can make law or amend the Constitution directly or indirectly? You see, with the pronouncement of the Supreme Court, as it has to do with the defection of 27 lawmakers from PDP to APC, if you allow the pronouncement of the Supreme Court to stand, then indirectly the Constitution has been amended and democracy in Nigeria will be truncated. Because as it stands now, it is absolutely impossible to prove defection in any court of justice, except you can only go to a court of technicalities where the judge will be compromised, as we see it daily in Nigeria today. If the court is now saying you have to produce the membership card of a House of Assembly member who defected to a new party, you have to produce the membership register of the new party he defected to. That membership register must reflect his name, must contain his name for you to prove defection. Then it's like making an entirely new law. And by this new provision, it is impossible to meet that condition. Go to the wards and see how many parties have a functional secretariat where you can go and look for a particular document or register. How many parties even have registers of members they can present to anybody? We have a situation whereby a Nigerian politician can be in this party today and tomorrow he already jumped to another party. His name may be in this party and his name will also be in the other party. That is the situation. Nobody can deny it. Tell me that House of Assembly member that will make available to you membership ID card for you to use to prove that he has defected. It is absolutely impossible. But why will 5 Supreme Court justices embark on this, what looks like a crime against humanity? making unguided pronouncement. If a lawmaker will write a formal letter, sign it, and deliver it to the Speaker of the State House Assembly, and the letter of defection will be read on the floor of the State House Assembly, what is the Supreme Court talking about again? When they are talking about there is no evidence of defection, what other evidence? If this same lawmaker will appear before the court with an affidavit as an APC member who has defected from PDP to APC, this is now a court document showing that this person is an APC member. What other evidence is the court looking for? That is the problem.
Court says only the House can declare a seat vacant over a defection and not the governor of a state. Not even the court can do so. Now, for the cross-appellant, that the 27 members have defected has no evidence. It is not shown or suggested that their names are now in the register of members of another party, or that they have obtained membership card of that other party. Membership register and membership card constitute the only proof of membership of a political party.
Can the judiciary amend or make new law? You see, this is just a crafty way of serving the vested interest of certain power that be. This pronouncement was made to achieve a particular purpose. The matter before them was not to determine whether those lawmakers had defected or not, whether there is evidence of defection or not. The argument was not whether they have defected or not. That was not the argument. That was not the subject matter brought before the court. Can the Supreme Court make laws or amend the Constitution of the Federal Republic of Nigeria? What they are toiling with is the destiny of over 200 million Nigerians. This pronouncement about what it will require, what it will take to prove defection must be set aside for the good of Nigeria. If you allow this to stand, then forget it. Democracy will suffer beyond measure in Nigeria. Already, what we have is not democracy. Let the authorities do the needful. The National Judicial Council should do the needful. The Nigerian Bar Association should review what has happened and take necessary steps. We need to act fast. Can 5 Supreme Court justices amend the Constitution to tell you if a lawmaker will officially write a letter and appear before court with an affidavit that he has defected to a new party? Then you are still asking for evidence to prove defection. You need to bring his membership card. Where are you going to get it? Will you force him to produce it? You need to go to his own world, his own local government, his own community, and get the party membership register containing his name. This is so strange. Nigerian Bar Association, sit up and do something about this development. Save Nigeria and save our democracy. The judiciary should not be a thorn in our flesh. They should not be a cog in the wheel of our progress. Let something be done urgently. Let us share this video for the common good of all.